When you die, some, but not all of what you leave behind is considered part of your estate. For example, let's take the estate of Mr. Law Harp. The default legal process of figuring out who inherits what from his estate is called probate. In probate, the deceased's family asks a court to decide what to do with the estate's assets. Sometimes probate can be a very long, costly, and contested process, so it's usually better to either 1. Skip probate altogether, or 2. If you have to go through probate, make the process as easy as possible. But how? It's through estate planning. Let's look at the differences between two estate planning tools that are available to everyone. 1. A trust, and 2. A will. Since this is an introduction and isn't legal advice, we'll just get into the basics. With a trust, you are basically creating a new entity to hold assets. For example, the Hattie Harp Attorney-at-Law Trust for Children. After creating the trust, Hattie transfers his assets into the trust. This process is called funding the trust. Now the trust owns everything. Everything placed in the trust is now controlled by his documented trust instructions. And when Hattie dies, the trust lives on to continue serving its purpose. It's not so simple, though. Hattie must designate someone to run the trust and give that person power over the assets. This person is called a trustee. He must also choose who will benefit from the trust, called beneficiaries. In most cases, the creator of the trust can initially serve in the roles of trustee and beneficiary. When the creator dies or becomes incapacitated, those roles are passed on to successors that are named in the trust documents. So why do this? When a person dies, the assets owned by the trust continue to be owned and directed by the terms of the trust, not by a court. So trust-owned property can be directed, divided, and distributed by the trustee to the beneficiaries, according to the wishes of the person who set up the trust, giving them control over the assets when they are alive and when they are gone, without having to go through the probate process. So why doesn't everyone just create a trust? Well, realistically, not everyone takes this stuff seriously, at least not yet. Planning for death can be overwhelming and emotional. The upfront costs can be prohibitive. And, depending on your situation, there may be ways to avoid probate without setting up a trust. So the truth is that setting up a trust might not make sense for everyone. It really does depend on the specific circumstances and goals of each person or family. Remember when I said if you have to go through probate, there are ways to make it easier? That's what a will is for. A will is a signed statement that tells probate court things like, who should speak for you when you die? What do you want to happen with your things? Who should inherit what? And who should disinherit what, if that's what you decide.